Good morning, everyone. I'm delighted to address you at this year's Bitkom Privacy Conference. Today's programme has an impressive lineup of speakers and topics, and I'm pleased to delve into one of these topics further, the European Data Protection Law. The General Data Protection Regulation, commonly known as the GDPR, has been a game changer for privacy standards across Europe and globally. It has been a success story for both individuals and businesses. Its flexible, risk-based approach means it adapts well to new technologies. The GDPR has also laid the groundwork for all EU digital laws dealing with the processing of personal data, thus promoting a wave of innovation, which most importantly is aligned with our EU values and our rights. And this is the exact approach we're aiming for, something that protects personal data without stifling innovation. However, despite these successes, challenges, of course, remain. We still need to ensure the consistent interpretation and enforcement of the GDPR across EU member states. It's also important to support SMEs in complying with GDPR. The European Data Protection Board recently outlined new initiatives to make GDPR compliance easier, especially for SMEs, and to boost cooperation among regulators. In this regard, the Commission fully supports the Data Protection Authority's efforts to improve the application of the GDPR. And I'm also pleased that the negotiations on our proposal for better GDPR procedural rules have concluded, promising faster enforcement, especially in complex cases. But we also need to ensure the GDPR remains effective and relevant by simplifying some areas to make compliance easier. Our priority here is to ensure the GDPR remains in line with evolving digital challenges and meets law enforcement and business needs. In May, we proposed simplifying the GDPR's record-keeping obligation by exempting entities with fewer than 750 employees and raising the threshold of record-keeping to high-risk processing. This reflects our commitment to help smaller companies comply with the GDPR by cutting red tape and reducing administrative burdens. In July, I hosted an implementation dialogue to gather input from stakeholders on improving the application of the GDPR without sacrificing data protection. Feedback from businesses and civil society indicates satisfaction with the GDPR's balance. They don't favour a complete overhaul, but some industry representatives suggested targeted tweaks for clarity and to simplify obligations for data controllers. Industry representatives also called to maintain the GDPR's risk-based approach, especially with AI and other new technologies. Looking ahead, we'll use this feedback to shape future simplification actions that would best address stakeholders' concerns while enhancing EU competitiveness. Our discussions with stakeholders also revealed a need to clarify how the GDPR interacts with new digital laws, like the Data Act and the AI Act. The AI Act, building on the GDPR, will address AI risks to fundamental rights, and it will ban some high-risk AI uses, promoting responsible innovation. And given the increasingly complex digital rules, I'm glad the European Data Protection Board will work with the Commission's AI Office to create guidelines on the interplay between the AI Act and the EU data protection laws. This will help ensure consistent and coherent enforcement of the EU legislation. The Data Act, effective from September 12th, complements the GDPR, introducing its own requirements for data sharing and access. I value the European Data Protection Board's input on this and any comments the board may have to ensure the Data Act and GDPR form a cohesive legal framework on personal data use and access. Finally, data knows no borders, and neither should privacy protections. Citizens should know that wherever they go, their data is protected. The EU's data protection policy fosters international cooperation and promotes cross-border data flows. Over the past 5 years, the EU has collaborated with numerous countries and organisations to develop new forms of engagement and collaboration. Notably, in July, the EU adopted its first ever draft adequacy finding for an international organisation, namely the European Patent Organisation. The EU is also working on mutual adequacy arrangements, such as the existing agreement with Japan and the one now being finalised with Korea and the one we are negotiating with Brazil. As the world's largest digital services market, the EU seeks more adequacy decisions to facilitate data flows without the need for additional safeguards. Beyond adequacy decisions, the EU is expanding its data transfer tools, including standard contractual clauses. The G7 highlights that these clauses are widely used worldwide, promoting global data flow convergence. The EU's goal then is to continue connecting different transfer mechanisms. Maintaining strong, trusted relationships with countries around the world is crucial to ensure safe data flows and to boost trade benefits. To conclude, our focus is clear. We want to simplify where we can, harmonise new laws with the GDPR, and protect EU data globally. This requires collaboration across sectors, between lawmakers, businesses, and privacy experts. And let's continue to work together. By doing so, we can address today's challenges, but also prepare for tomorrow's opportunities. I want to thank you, and I wish you a fruitful conference.